Imagine a situation where you secure full marks in an exam, but you're still not able to get a seat in top college. That precisely is NEET 24. 5 facts quickly which demonstrates that this is a scam are as follows. Number 1, 67 students secured a full marks of 720 out of 720. Contrasted with this previous year, only 2 students had secured it. And surprisingly, 7 students from one center which were in the same line secured this marks. So this is an unachievable feat which you can't say that immediately that the students have suddenly become intelligent. Second, a 650 mark erstwhile would have fetched a rank of 10,000 around. This time, not even a 40,000 rank is being secured on this particular marks. Third, the most outstandingly glaring illegal act by NTA, which is National Testing Agency. Let me rephrase it to Notorious Testing Agency, is awarding of grace marks. NTA says some students comes to us, says that there was a delay in handing over examination, please give us grace marks. How much grace marks, to whom it was awarded, details of those students, of those centers not disclosed. Only a number disclosed, which is 1563 students. Now I ask this 2-3 questions to myself. On what basis the NTA had given this marks? There was no legal basis. Second, though this controversy gets fairly resolved to the extent that NTA has exceeded in the Supreme Court, that this awarding, they are scrapping out the award and they are reconducting the exam vis-a-vis these candidates. Now another question which arises is, all these candidates 1563 did not qualify. There were students who were also not qualified. So in fact, you are giving an opportunity to those students which had not even qualified. That's outstandingly amazing to me. Fourth, this whole scam got caught because there were certain students which got 718 to 719 marks, a feat which is statistically impossible. As to why? The marking on visages a criteria whereby there will be a negative criteria. Each question carries 4 marks, and if you don't attempt, that is -1 marks. So in any which ways, 718 and 719 marks could never have been achieved if the criteria is followed. So all this scam came into light because of this marking of 718 and 719. Now all this in light of the fact that there are cogent evidences of paper leak, recoveries of papers, arrests being made, confessional statements under 164 being recorded before magistrates. Now, just on a point, when a confessional statement is recorded before a magistrate, it accrues a very higher evidentiary value. All this, when is on record, then saying it is a prima facie case of paper leak would be an understatement, because it is probably much beyond that, much beyond the parameters of prima facie. So all this controversy, having said, is now before Honorable Supreme Court. As on date, Honorable Supreme Court hasn't given any interim stay or directions on the counselling or the admission process. The Supreme Court has listed this matter on the next date of hearing, which is 8th of July 2024, and there is no stay operating. The only way forward, I personally feel, the stakeholders, the students, and have to really up their game, re-mention it, re-mention their grievances, with certain facets being: number 1, the court needs to be further persuaded to have a look at the following facts. Number 1 being that all the OMR sheets, because there is a very pertinent and very important allegation that there may be there has been an artificial inflation of marks. Now all that makes those the preservation of those OMR sheets very important. Thus the possibility of tampering cannot be ruled out until unless those are preserved by court order. Therefore, that's point immediately, because the next date is 2024 days ahead. Second, the most crucial limb in this whole examination fiasco has been grant of or awarding of grace marks basis the request of certain students at certain centers because of delay in handing over examination papers. Now, let us take note of the fact that all that can be culled out by examining the CCTV footages or other corroborative materials. These students, the mobile records and or social media records, meaning WhatsApp and all of these students and at these centers. Now, all that, if there is an inordinate delay and then there is a probe which is ordered after 2-3 months, then there is a high possibility that this data, this evidence is lost forever. So it will be more or less of an exercise, a futile exercise, which may not be very beneficial to the students. Fourth, the court has to be persuaded to examine this from the angle that it is not mere legal right of the students which is getting violated or getting infringed. It is the fundamental right to a fair examination and assessment, which is the bounden duty of the government, the central government in this case. Therefore, what has been violated is not merely a legal, it's the fundamental right of the students. And therefore, along with the with the main prayer being the reconduct of exam, there has to be some answerability imposed upon the government, some damages being imposed upon them, compensatory. Why should students suffer the harm? And that is all I would seek, and probably request the stakeholders that don't give up your stand till 8 July. Make an attempt on new grounds, so that, because otherwise it will be a exercise where it will be a operation successful and patient dead. And therefore, that's my limited observations. And thank you.